Welcome to Business Legal Lifecycle TV, the live TV show all about the legal aspects of your business to help educate you on complex legal terms in an easy to understand manner, to help understand why you need to do certain things in your business from a legal point of view, and to help you develop a plan for the future. Our mission at Business Legal Lifecycle is to help empower all small to medium-sized businesses around the world to get access to legal advice so that they can help build their communities and make the world a better place. Did you know that any business owner is on average 7 months away from losing everything? That is the average time it takes from a successful business to fold when an aspect of their business is not set up correctly. Have you ever wanted to get legal advice but didn't understand what was going on? Do you feel like there is a divide between lawyers and their clients? Then this TV show is for you. It is all about empowering you and your business with the knowledge and tools to ensure that this doesn't happen to you. Business Legal Lifecycle TV delivers a twice-weekly show focusing on the legal aspects of your business. At lunchtime on Mondays, we present Fast Fix Monday, a quick 5 to 10 minute show that will give you some actionable steps to consider for the week for your business. And at lunchtime on Wednesdays, we present our in-depth show of between 30 minutes and an hour, where we go through complicated legal aspects of your business in a simple to understand, plain English manner. And whether that is through educational pieces or interviews with experts in their fields. Hi everyone, and welcome to Business Legal Lifecycle TV. My name is Jeremy Stretton. I am one of the founders at Business Legal Lifecycle, and this show is show 107, and it's our monthly legal updater for July 2018. So this is a show that we've introduced in 2018 to go through legal changes that from Australia and around the world that will affect business owners. Last month, we interviewed Kim and Brett from Vincent's about the budget, and we didn't talk a lot about the changes. So this month, I'm going to go through the June and July changes so that you're aware of it. Welcome to anyone who's listening to us on our podcast. And without any further ado, I will get into this month's legal updater. So the first change that's come in is the comprehensive credit reporting. So this is where additional information is being provided to or held by credit reporting bodies in Australia. It will allow licensed credit providers to access and use that information in order to make sure that they're making informed lending decisions. Bodies need to be ready to start this reporting by the 1st of July, so the beginning of this week, and the big banks and various credit providers have had to start it back in February 2018. So basically it includes all the information that's in your credit file. It'll be stored for 2 years, and people are going to have access to it to be able to make sure that they can give you credit. People like businesses such as telephone and utility companies are not credit providers, so aren't included. So what does this mean? Essentially, the credit reporting industry will have a more complete picture of an individual's credit profile, and people with a good payment history are going to get a higher score, and ultimately those with lower scores will have to find a way to improve them. So that's the first one, comprehensive credit reporting. The second one is gambling in the United States. So for our listeners in Australia, you may be surprised to learn that up until May, it was illegal for sports betting to occur in the United States. But in mid-May, the United States Supreme Court struck down a law banning states from legalizing betting on sporting events. So the Supreme Court said that the 1992 legislation, so brought in many, many years ago, over 25 years ago, known as the Professional and Amateur Sports Protection Act, was unconstitutional. The legislation barred states, except for Nevada, to allow sports gambling. New Jersey, the state of New Jersey, challenged the legislation as being unconstitutional. And originally, some of the major sporting bodies actually opposed the case by New Jersey. But in the end, many of them actually supported New Jersey's case. They supported it because, and they actually wanted the legislation to come in because they thought that, saw that back before 1992, a lot of their athletes were being getting on the wrong side, let's say, of decisions and of sporting betting syndicates. So what does this mean? That the legislation that was brought in, after a spate of sports team match fixing is now unconstitutional. New Jersey will be probably the first state, if it hasn't already, but it probably has already, and if it hasn't, it will soon. It will proceed with implementation, and we have no doubt that other states will follow through. The third thing that we wanted to talk about is off-the-plan contract GST collection. Now, in Australia, we have a tax, many people will know this, called the Goods and Services Tax. So this is where you need to pay 10% of the price of a good or a service, and you pay that as duty. Now, what happens is that property developers often have to pay GST on their price. Now, it's not usually 10%, and it's usually included in the price. But the ATO has basically got sick and tired of property developers not paying that money directly. So what they've done is, as of the 1st of July 2018, so the beginning of this week, where a property is sold off the plan and certain other residential properties, and GST is paid as part of the price, the buyer must pay the GST directly to the ATO. So as I said, this was done to ensure that the GST was paid to the ATO, as sometimes it was missed, or there are other circumstances where it wasn't paid. By making the buyer pay it at settlement, the ATO is ensuring that they get paid. Even if you are not in business, if the tenor of your property transactions and other transactions are more than the GST registration threshold, and your other activities are regarded as an enterprise, you are required to be paid for GST. A lot of property developers in Australia do not think that they have to be registered for GST. So make sure that you're registered. What does this mean? In the past, GST was, like every other transaction, collected by the seller of the off-the-plan property. This is the same as every other transaction. When you buy food or a drink or use legal services, the vendor is a tax collector for the government. This has been turned on its head now. It is now the buyer that actually has to collect the GST. Now, it only applies to contracts that entered into from the 1st of July, so which was the Sunday, the beginning of this week. And if you're listening to this later, 1st of July 2018, you'll know when that was. But from contracts that are signed up from that time, buyers will need to pay the GST. This is just another reason that if you're a buyer or a seller of property, that you've got to make sure that you get good legal advice before you buy the property. Sellers actually need, the process will work this way, that sellers actually need to work out what their GST requirements are. There's a certain format of a notice that has to be given to buyers before settlement, and then that notice comes in on that day. So this is one of the laws that comes in the 1st of July 2018. Another law that comes in July 2018 is the change in the tax rates. So from the budget program, you'll remember that we talked about the change of tax rates for individuals in Australia. Well, they passed recently through the both houses of parliament. So as of the 1st of July, those tax rates are now applicable. And the other one, that if you're living in Queensland, where I am, you'll know that the single-use plastic bag ban, say that 3 times really fast. Plastic bag ban. I can't even get it right the second time. Bag ban comes into effect this month as well. So this means that you can't go to this major supermarkets or any supermarket or any shop and get a plastic bag. You need to use reusable bags. So all of those things come in on the 1st of July 2018. So make sure that you're in over it. And if you've got any questions, you can always let us know. I wanted to finish off, having not done the news from ASIC and the ACCC in June, we've got a lot of notices. We get a lot of information from the ACCC and ASIC. So we've distilled down. I've got probably the top 6 things that we thought were important to get across to you so that you knew what was going on. So the first one was in May. The Japanese company Tsuzuki Corporation was ordered to pay penalties of $46 million for cartel conduct. This is the highest penalty ever handed down by the courts in Australia for a breach of the Competition and Consumer Act. Essentially, it was found that this company, Tsuzuki Corporation, had engaged in the coordination of quotes with another company to Toyota for the supply of wire harnesses used in the manufacture of the Toyota Camry car. Originally, the judge ordered a fine of $9.5 million, but the ACCC appealed this and achieved a much larger fine. I'm sure you'll agree with me that $46 million is a lot of money. The second one is that Hewlett-Packard PPS Australia has been forced to compensate consumers who were not advised when they brought printers in Australia that they could only use Hewlett-Packard branded cartridges in their printers. The feature was known as the dynamic security feature and is a problem that so many people have with printers these days. And it was designed to prevent non-Hewlett-Packard ink cartridges from being used in their printers. Over 220,000 of these printers have been sold, and now Hewlett-Packard needs to compensate the people who bought these for failure to disclose the restriction. It's a lot of money, and it's a lot of people who have been wronged by Hewlett-Packard trying to basically restrict what people can do. So the third one is that ASIC has announced that it is attempting to identify accountants who are giving advice about setting up self-managed super funds without a particular license to do so. On the 1st of January 2016, new legislation meant that unless an accountant had obtained an Australian financial services license or was duly authorised under an Australian financial services license, they could not provide advice in relation to the setup of self-managed super funds. If you are still giving that advice, you should stop giving it straight away. Update your website and make sure that you comply with these requirements. Now, I work with a lot of accountants. I talk to them several times a week, sometimes every day. And I know that a lot of accountants don't like this change. However, it's the law. You need to comply with it. If you're unhappy with it, you need to lobby the government for a change, but you need to comply with the law. So please make sure that you do, because I do not want to see you being fined for something that you shouldn't be doing. Get financial advice. Refer your clients off to financial advice. And you know what I find? When you actually refer a client off to get alternative advice, they love it. And the referrer loves it, and you might actually get some work back. I can't promise anything, but it works for me. The fourth one is that to advise everyone that ASIC is also focusing its efforts on misleading or deceptive conduct in initial coin offerings. So yeah, this is going out in July 2018, and in recent years there's been an absolute explosion in the number of initial coin offerings. So these are, for anyone who doesn't know, basically an IPO for coin or cryptocurrency of some sort. And ASIC has received powers earlier this year, we actually updated that in a previous show, to take action against these companies. Because a lot of people are putting a lot of money in without really understanding what they're doing, and they're losing a lot of money. So ASIC is calling on information from people who are concerned about ICOs that they've seen to report them and the conduct of the people making the initial coin offering to them so they can investigate it and prosecute if necessary. So if you know anyone, or if you know anything about an initial coin offering that you don't think was fair and reasonable, get in touch with ASIC. They want to know about it, and they want to stamp out the problems that we're seeing in that industry. The fifth one was from the ACCC, and it is news that Apple has been ordered to pay $9 million in penalties for iPhone and iPad misrepresentations. Basically, Apple has admitted to misrepresenting to customers that if they receive what was known as an error 53 and they had their device repaired by a third party, then they weren't entitled to get their device repaired by Apple. This was actually a breach of the Australian consumer law. Companies like Apple and the people who work there in the Genius Bar or wherever often didn't understand a lot of the Australian consumer law, which is designed to protect the consumer. And so Apple has been ordered to pay $9 million in penalties for that breach. And it's interesting, a lot of people challenged them, and Apple did push back, and it's been shown that the consumer is right. The final one, the sixth and final one, is again from the ACCC, and that is that the Federal Court of Australia has upheld decisions against LG Electronics Australia, made misleading representations to customers, saying that the customer had no guarantee for their product. Again, this is a breach of the Australian consumer law, and LG was saying, no, it wasn't. We don't have to compensate our customers. Well, they do. And so if you think that these things might apply to you, then let us know. Or contact the ACCC, because they are interested and they are in the business of stopping companies from getting away from these kind of things. And also, it could be the fact that they just didn't understand the law. These big companies have a lot of employees, and sometimes those employees don't understand the law, and they may just be reading from a manual and not really realizing what was going on. So be wary of that. Know that you've got rights, that you can get advice. So make sure that you get it. So look, that's it from this July 2018 version of the monthly legal updater. My name is Jeremy Stretton, one of the founders of Business Legal Lifecycle. If you've got any questions, please feel free to email me at lifecycle@jeremystretton.com. You can make comments on our Facebook page if that's how you get consuming our content, or YouTube and Periscope. We love answering questions. We love helping you guys. We want to help business owners to really understand what's going on in their business legally, so that we can help stamp out the problems that I see far too often in businesses, of business owners basically just not getting what they deserve for their business. So if you've got questions, feel free to ask them. We're happy to help. As always, we have show notes for this episode. They'll be up by the time this goes live. businesslegallifecycle.com.au/107 for our 107th show. Please feel free to contact me, and have a great weekend. We'll be back on Monday with another edition of Fast Fix Monday. And until then, have a great weekend. Bye.